Right now, though, we're focusing on Bakersfield, California. The closing arguments underway for a mom who allegedly got some filler in her buttocks while one of her 2 kids that were left in a vehicle died after overheating. The car turned itself off after an hour, and Maya Hernandez is standing trial for second-degree murder. Here, her defense says, yes, this is manslaughter. It's child endangerment, but not second-degree murder. So let's pick up the closing arguments where we left off, where the prosecutor is going over what it takes for a second-degree murder conviction, which she believes is in order.
Defendant committed an act that caused the death of Amillio. When the defendant acted, she had a state of mind called malice aforethought. Malice aforethought is defined for you in the instructions. In your instruction for this charge, instruction 520, there's going to be one single sentence that tells you what express malice is. That sentence can be ignored. This is not a case of express malice. I am not, and I will not argue to you this morning that the defendant had an intent to kill Amillio. We are here for implied malice. And implied malice means she intentionally committed the act. She intentionally left Amillio in the car. That's the act that satisfies the first element of implied malice. The natural and probable consequences of the act were dangerous to human life in that the act involved a high degree of probability that it would result in death. She left Amillio and Mateo in the car for 2.5 hours in the middle of a Bakersfield summer in extreme heats. At the time she acted, she knew the act was dangerous to human life. Ladies and gentlemen, I submit to you that I anticipate most of what this case and today's arguments are going to rely on falls right here. At the time she acted, she knew the act was dangerous to human life. You know, based upon her interviews with Detective McNabb, based upon her actions, based upon her failures to tell anybody inside of the spa that she had her children with her, that she knew her acts were dangerous, that she knew they were dangerous to human life. She got in here and she testified and she told you a different story. I will spend some time going over which of those statements is going to get you where you need to go. And she deliberately acted with conscious disregard for human life. She knew what she was doing, she knew it was dangerous, and she did it anyway. She knew it was dangerous to leave the babies in the car, but she did it anyway. She did it anyway because that day, June 29th, 2025, was about Maya. It was about Maya's wants, Maya's needs. That day was never about Amillio. It was never about Mateo. And it was never about protecting the boys. Second-degree murder, failure to protect. This one, first element, the defendant had a legal duty to protect Amillio, and the defendant failed to perform that duty, and that failure caused the death of Amillio. You will see in the instruction for this crime that a mother has a legal duty to protect. You don't have to guess on that. You don't have to speculate. That is the law. You know that the defendant in this case is the biological mother of both Amillio and Mateo. You know that it was her duty to protect as the mother, and she failed to do so. She gave you this element when she testified. She said she knows she failed to protect them. She failed to protect them because she should have brought them in with her. She should have left them with a babysitter. She should have done absolutely anything, ladies and gentlemen, other than leaving them in a car to burn and perish. When the defendant failed to act, she had a state of mind called malice aforethought. Implied malice, again, ladies and gentlemen, the same requirements for both ways to get to second-degree murder. The only thing that changes is the act versus the failure to act and the failure to perform her duty as a mother. We often hear the term malice, and in ordinary language, that sounds like a bad word. Like that sounds like we have to have hatred, ill will. No, ladies and gentlemen, not in this courtroom, not in the law. The law will specifically tell you when you're looking at Calcrim 520, malice aforethought does not require hatred or ill will towards the victim. The defendant did not have to be mad at Amillio. The defendant did not have to hate Amillio. It's okay that you saw those photographs of the defendant showing affection and loving Amillio. None of that negates the elements of second-degree murder. Nothing that you saw in those photographs negates implied malice. It's okay that she wasn't upset with Amillio. It's okay that she didn't hate him. It's okay that she did not intentionally kill him. Because none of that is required for second-degree murder, ladies and gentlemen. Now that you know the charges and the law that apply to those charges, how does that intertwine with your duties, with your job as the jury, ladies and gentlemen? It is now your job to decide what happened that day. It is your job to decide what was the defendant thinking that day. What did she know before she got out of the car? It's your job to decide that. And you decide that by taking all of the evidence you have heard, the witness statements, the testimony, the photos, the defendant's recorded interview, text messages to the nurse. You get to take all of that and you decide what happened that day. You decide what was she thinking that day. You apply that to the law. And once you do that, you come to a conclusion. And that is your job, ladies and gentlemen, as the jury. We told you during voir dire that you can't come in with special knowledge. You can't come in with your own medical opinion as to what happened. You can't come in with any preconceived notions about what happened. You can't come in with, oh, the media said this, I'm going to believe A, B, or C. But the one thing we never asked you to leave outside was your common sense. And that's because your common sense is of utmost importance in your deliberations and your deciding what happened in this case. Do not leave your common sense in this courtroom when you go into the jury deliberation room. Take it with you and use it. How did we get here today, ladies and gentlemen? As I previously described, the defendant made an appointment to drive from Visalia to Bakersfield to receive a cosmetic procedure. Now, when she initially testified on direct, she attempted to make it sound like this was a last-minute sort of thing, that she had to come and there wasn't really much time.
All right, the closing arguments continue in Bakersfield, California. We'll get a break. When we come back, we'll head back to Bakersfield. Plus, the very latest on Nick Reiner, expected to be in a Los Angeles courtroom, and he is a new lawyer, Alan Jackson. Welcome back to Court TV Live. Some news out of Southern California concerning Nick Reiner, who is facing 2 charges of murder for the deaths of his mother and father, Rob and Michelle Reiner. Alan Jackson is now representing Nick Reiner. He, of course, is the attorney who a lot of us watched during the Karen Reed case. He's as high profile as it gets in Los Angeles. And according to Alan Jackson, he says that his client will not be in court today, Tuesday, for medical reasons. Jackson told reporters outside of the courthouse that he didn't know the medical reasons, what the issue was, but said that his client, Nick Reiner, will not appear before Wednesday. Alan Jackson just coming on board on this case. Our Cody Thomas is at the LA courthouse. We'll have more throughout the day as now this takes a little bit of a different turn when someone like Alan Jackson enters the fray. That's for sure. Marie Pereira with us quickly. Marie, before we head back to Bakersfield for more of the closing arguments in that case, your thoughts on A, Alan Jackson representing Nick Reiner, and B, medical issues. We do know he was on suicide watch, will not be in court today.
My immediate thought is that they hired a big gun. And from what I know about the son, how is he affording an Alan Jackson? It lets me think that the family support him. And it lets me believe that the medical condition is mental health Even though we don't think mental illness is like physical illness, it is a medical condition. And I believe for him to engage in this sort of parricide, killing both his parents in such a brutal way, he had to have some sort of a mental illness. And I anticipate mental illness, drug use, addiction, and the effects of the drugs on his mind is going to be a big part of Alan Jackson's defense. And they did hire big guns, and it shows family support because, again, a man like Alan Jackson, with his skills, doesn't come cheap.
Absolutely, a family ripped apart because of the actions, apparently, of Nick Reiner. That is not a live look. That is just a tape of Alan Jackson. Of course, we know him well. Here at Court TV, we'll continue to monitor, but the headline at this hour is that Nick Reiner will not be making his initial court appearance as we first expected because of a medical issue, and that Alan Jackson has been retained to represent Nick Reiner moving forward. So we'll continue to follow that throughout the rest of the day. Our Cody Thomas will be joining us throughout the day today. For now, let's stay in California, but head 90 miles north of Los Angeles to Bakersfield, where we're watching the critical closing arguments in the cosmetic filler child killer case for Maya Hernandez. She's charged with murder after allegedly leaving her children in a hot car while she went into a medical spa. Her 1-year-old died after being hospitalized. Her 2-year-old did survive. Hernandez took the stand on Monday before the defense rested, telling the jury that she believed at the time that her boys would be fine. The air conditioner and the vehicle were on. Unfortunately, that vehicle would shut off after it was parked and unattended for an hour. Let's go back in, pick up the closing argument on behalf of the state of California.
But you learned on cross-examination that that was not the case. That she knew about this appointment for at least days ahead of time, and that she had been attempting to schedule this appointment since early May. But more importantly, ladies and gentlemen, you know that this was not a mandatory procedure. This was not a procedure that she needed for her health or well-being. This was an elective cosmetic procedure for the sole purpose of enhancing her looks and helping to make her feel beautiful. So any statements that I didn't have enough time to decide what I was going to do with him or find a babysitter, those go out the window. Because this was all based around the choices she made. This was not an emergent situation. It was not a last-minute situation. The defendant made the choice to drive to Bakersfield with the 2 boys, Amillio and Mateo. She knew before she left home that she could bring the boys inside the spa with her. They would simply have to wait in the waiting room. She knew that she had a stroller in her car that both of the boys could sit in, be strapped in, just like in their car seats, and sit in the spa. She chose none of that, ladies and gentlemen. She arrived in Bakersfield. She chose to go inside at approximately 2:04 p.m., and at that time, she chose to leave her children in the car. She sat inside that business in the same chair from 2:05 to 4:09 p.m. Did not move from the chair, ladies and gentlemen. You watched that. She didn't get up to check on her appointment time. She didn't get up to ask how much longer. She didn't get up to tell anybody she was in a hurry. She didn't get up to check on her kids. At 4:09, she goes back for her procedure, and at 4:33, she leaves the building. Even at this time, ladies and gentlemen, 4:33 p.m., she does not leave to go check on her kids. And you heard that through her interviews with detectives. She left to go get her phone to pay. Even when she left at 4:33, her children were not the priority. She did not leave to go get her children. She left to go get her money. Again, with Maya as the priority, not her children. After a 911 call is made at 4:40 p.m. on that day, officers are dispatched around 4:43 p.m. and arrive approximately 4:45 p.m. at the business that day. By the time officers arrive, This was Officer Velez Aguilar and Officer Fajal. Hall ambulance personnel are already on scene providing treatment to Amillio. You saw the body-worn camera, ladies and gentlemen. You saw Amillio's lifeless body on the gurney. Amillio was ultimately transported to Adventist Hospital, where he was treated by Nurse Gabrielle Long and Dr. Thomas Riley. You heard from both of those witnesses. You heard that at the scene, officers also observed Mateo. Now, by the time officers saw Mateo, he was soaking wet, he was red. A lot of that water, that soaking wet, did in fact come from efforts of Harmony and Shelby to cool him down, putting water on him, pouring water on him. But you also heard from Shelby and Harmony that before they started putting water on Mateo, he looked like he was about to have a stroke. He was hot to the touch, and he was sweaty. You heard Ian Blue describe Mateo. He said, it's a term we use in Spanish. It means kind of like wet chicken. The way he looked with his hair wet and stuck to his face when he went into the business. Mateo was also transported to Adventist Health Hospital. Amillio arrived at the hospital at about 5:00 p.m. He was ultimately pronounced deceased at 5:48 p.m. I apologize. You heard from Dr. Riley. They were as aggressive as possible in their attempts to save Amillio. They were as aggressive as possible in resuscitating him. They were as aggressive as possible in attempting to cool his body. They did cool his temperature from about 107 to 101, but that was not sufficient because it was too late. And you heard from Dr. Riley that early intervention could have saved Amillio. The defendant going out to her car to check on Amillio could have and would have saved Amillio. You heard Dr. Riley talk about how heartbreaking it was to see a 12-month-old in the condition Amillio was in. That it was gut-wrenching that he was unable to save Amillio on that day. He even said at one point, physicians are humans too. They don't put on a cloak and not have feelings. And he explained those feelings to you of seeing a 12-month-old boy come in completely lifeless. We'll talk more about his testimony in a few minutes. Mateo was transported to the hospital. While in the hospital, his temperature was approximately 99 degrees. He was fine and he was ultimately released. You heard Nurse Elizabeth Bond explain to you the difference why Mateo was okay, but Amillio wasn't. And it was because of their age. Amillio was not yet able to regulate his inside temperature because of his age. Mateo had more developed sweat glands, which explains the sweat on the outside of his body when he was located. Video surveillance. The detectives had information. The defendant told them, I left him in the car for 2 hours. She was very forthcoming about that from the start, ladies and gentlemen. The detectives could have rested on that and been like, okay, she told us. They wanted to see what happened that day. They wanted to make sure this was a complete and thorough investigation, so they got the video surveillance from the business. In that video surveillance, you can see the defendant walking up to the business at about 2:04 p.m., ultimately takes the seat by not the west door, but the door across, where she sits for the rest of the time until 4:09 p.m. At 4:09 p.m., you see the defendant get up and walk in the area that we have been told is the area of the rooms for service, room B6. You also saw that and can see that on the body-worn camera footage of Detective Barthelms conducting the measurements into the building. The defendant ultimately leaves the building for the first time at 4:33 p.m. You heard about the search of the defendant's vehicle. The infotainment screen was broken. They were not able to get any immediate information from the infotainment system about what specifically was happening in that car. There was a bottle found behind the passenger seat right by where Amillio's seat was. And ladies and gentlemen, this might seem very minor, but it's not. You heard that the bottle found by Amillio's seat was 2/3 full. You also know that Amillio was strapped into his car seat. He could not get out. If he dropped that bottle while he was still okay, he had no liquids to drink. If he dropped that bottle after he had began to perish, he began to perish pretty quickly before he could even get halfway through his bottle. Neither of those.
All right, let's get a commercial break. Again, the prosecution looking for second-degree murder here, laying out their case one more time for this jury in Bakersfield, California. We'll get a break and return. Pick up the prosecution's closing argument where we left off after this.
Tonight on Closing Arguments, a deadly shooting at Brown University and a killer at large. Court TV's Matt Johnson is on the ground with the very latest.
Closing Arguments with Vinny Politan, tonight at 8/7 Central, only on Court TV.
A Microsoft executive gunned down. Now his ex and her new husband are charged with his murder.
A social media sensation, now a suspected killer.
She wrote a children's book about her husband's death. Now she's accused of killing him.
Let's head back to Bakersfield, California. We're watching closing arguments in the cosmetic filler child killer trial for Maya Hernandez. She's charged with murder in the hot car death of a 1-year-old little boy, Amillio Gutierrez. Her 2-year-old son was also in that car, but he survived. Let's go back in, pick up the prosecution's close.
Neither of those scenarios is beneficial to Amillio. Both of those scenarios tell you that had the defendant gone out to check on them, she could have fixed the situation. You also heard that the defendant had a stroller in the trunk of her car. This also might have seemed like a fairly insignificant find when you heard the evidence. But you now know that it was not insignificant, ladies and gentlemen. This piece of evidence is not insignificant. This piece of evidence tells you that the defendant had the means to bring the kids inside with her. She had the means to literally put them the same way they were in the car. Sit each of them in their seat, strap them with the harnesses that you saw in Defense Exhibit 10, hand them the phone, and let them watch TV. Same exact condition they were left in the car. But in the stroller, they would have been inside, out of the elements, not subject to the heat, and we wouldn't be here today. But Amillio would. But the defendant chose not to use the stroller because that would have meant that she had to watch them and control them while inside the business, and that is not what she wanted to do on that day. You heard from witness Shelby Murch that she was a patron that day at the med spa. She was also waiting for her procedure. She was there approximately 30 minutes before the defendant arrived. She told you and she described for you the atmosphere in the waiting room. And you ultimately got to see the atmosphere, ladies and gentlemen, but Miss Murch described it for you before you saw the video surveillance. And what you saw in that video surveillance perfectly matched what Miss Murch told you. It was a friendly, welcoming, lively atmosphere. People were chatting, they were talking, there was another child. While the defendant was in the waiting room, she was bubbly and engaging in conversations with the other patrons. Bubbly and engaging in conversations with the other patrons, she told them that she had 2 little babies. She told them what her plans were for the 4th of July in a few days. What she didn't tell anybody inside of the waiting room was that her 2 little babies were actually there. What she didn't tell anybody in the waiting room was that her 2 little babies were strapped in her car. She testified, "Oh, I didn't tell them because they're strangers and I don't want to tell them about my life." But ladies and gentlemen, this is where you get to use your common sense. You know better. You know that's not why she withheld that information. She was talking to these people about getting things injected into her butt. She was talking to them about her plans. She was talking to them about the fact that she had children. Oh, but the fact that she had them with her was simply too personal? No, ladies and gentlemen. She knew that it was wrong and that it was criminal, and that if they knew, she would have a problem. That's why she didn't tell anybody her kids were with her in the car. After the defendant's procedure, the defendant left the building and went outside. Shortly after, a few minutes later, the defendant came in carrying Amillio. Amillio, who was completely limp, turning colors, his limbs just hanging. She came in and brought Amillio into the nurse's room. Shortly after that, Miss Murch saw Isabel Carrion come in with Mateo. And Shelby described to you how Mateo looked. He was gasping for air, had bubbles coming from his mouth, had peed through his diaper, sweat through his onesie, was holding an empty bottle. You also heard that he looked like he was going to have a stroke, and that when she touched him and held him, he was hot to the touch. And ladies and gentlemen, these characteristics, these observations are of the child that survived. These observations, gasping for air, bubbling mouth, hot to the touch, those are of the child that is okay. Imagine what Amillio was going through. She and Harmony took Mateo into the bathroom where they put water on him, tried to cool him down. They continued their attempts to cool him down when they brought him back out. You actually saw those attempts in the video surveillance where Shelby's holding Mateo and Harmony's patting under his clothes with the wet cloth, trying to cool him down. Then they go and rinse out his dirty milk, rotten milk probably at that time, bottle, and fill it with water for him. And Shelby also told you something that was very telling, ladies and gentlemen. While the defendant was in the waiting room, she was approached and asked by another mother, the mother and grandmother combo sitting on the black couch, to watch their child while she went to the bathroom. And the defendant did. This was over an hour before, and you can see it in the video surveillance, over an hour before the defendant went into her procedure. At that time, she knew people in there were staying. They were waiting for their appointments. They were willing to help each other out. She knew she could have asked one of them, hey, if I bring my kids in here, can you watch them for the few minutes I'm in my procedure? She knew there were options. She chose not to take those options because that would have interfered with her break. At some point, another husband, wife, and another child came into the waiting room. You saw that, ladies and gentlemen. It was the man and the young boy that sat just around the corner from the defendant's chair. You also heard from Ian Blue. He went to the location with Shelby that day. They were friends. You heard from both Ian and Shelby that it was so hot outside. Before they went in, they stopped at the gas station to get ice cream. It was a noticeably hot day. You heard from Ian that throughout the time the defendant was in the waiting room, there were probably about 10 people in total that came and went and were waiting. You also saw that when you watched the video surveillance. You heard from him that the waiting room atmosphere was friendly, engaging, and all the women were talking to each other. This was not an environment, ladies and gentlemen, that is meant to be serene, calm, quiet. That was not this waiting room. This was the waiting room that would have been conducive to kids. This is a waiting room that was conducive to kids. This was a waiting room that had kids in it and that the defendant knew had kids in it. You also heard from Ian, and this was the very important part of his testimony. that at approximately 3 p.m. on that day, he went outside to take his dog to go to the bathroom, Bowser. When he was outside, he was standing by the tree, right by the fence, about 2 to 3 feet from the defendant's car. And he was very clear and unequivocal when he told you, ladies and gentlemen, that that car was not running. There were no signs that that car was running, that any of the systems were running, that there was any air conditioning going on at about 3 p.m. He also told you he had no idea there was anybody inside of the vehicle. There was absolutely nothing to indicate there was anybody inside of the vehicle, and he was unable to see inside due to the dark tint. While Ian was outside, he noticed it was so hot that he had to bring Bowser back inside to get water. Ian recognized that it was too hot outside for his dog to remain outside during the same time of day that the defendant had her kids.
Oh, what to do with this young mother of 2? Remember, the prosecution wants second-degree murder. The defense is shooting for a manslaughter convictions. Both sides agree on one thing, that what she did was horrible and she should be punished. Stay with us. More of the closing arguments after this. Welcome back to Court TV Live. We are in Bakersfield, California, watching closing arguments. Before we head back to the courtroom, quick check in Nevada, where a sentencing hearing is underway for defendants Jesus Ayala and Zamir Keys. The 2 men pled guilty back in October to the murder of a former police chief, 64-year-old Andreas Probst. Authorities alleged that the 2 men used a stolen car to hit Probst as he rode a bicycle in a local neighborhood. That is a very emotional hearing going on in Vegas. We'll have that for you later this afternoon. But right now we're in Bakersfield, California, watching the closing arguments in the case against Maya Hernandez. The mother of 2 is accused of leaving her 2 young sons in a car for more than 2 hours, causing the death of her 1-year-old baby boy. Her 2-year-old survived. She testified yesterday tearfully, recounting her version of events. Hernandez standing trial now for second-degree murder. That's the top charge. That's what the state of California wants this jury to come back with on a guilty verdict. This defense, on the other hand, says involuntary manslaughter is the appropriate punishment for this young mother of 2. Let's go back into the courtroom for more of the state's closing argument.
Essentially locked in an inferno with rising heats. Ian thought it was too hot for his dog, but the defendant did not think it was too hot for her babies. Ian was back inside of the business when the defendant left, and shortly after, the defendant came back in with Amillio, followed by Mateo with Miss Carrion after that. And this is where Ian described Mateo as looking like a wet chicken, which is a term that's commonly used in the the Spanish language, according to Mr. Blue. Mr. Blue explained to you that Mateo looked like he was going to have a heat stroke and was gasping for air. These statements, ladies and gentlemen, they might sound redundant. Why did we have to hear the same thing from Shelby that we heard from Ian? And that's because, ladies and gentlemen, these statements show you that they're true. 2 different people made the same observations and came in and told you the same thing. That is evidence. That's corroboration that what they saw actually happened. Their testimony is supported by other testimony, other evidence. And while Ian was on the stand, he talked about some of the conversation that was happening inside of the business. He told you, ladies and gentlemen, that when the man and his son came in, there was a statement made that they had to come in because it was simply too hot to wait outside. This statement was made in the same vicinity, in earshot of the defendant. You know this because Mr. Blue specifically told you that he interpreted for the man and he repeated the statement loud enough for everyone in the room to hear. Not only was this statement made, ladies and gentlemen, there was a conversation that followed. A conversation whereby the people in the waiting room started almost joking about the fact, yeah, imagine how hot it is outside with how warm it is in here, and we have some air conditioning. Those conversations, ladies and gentlemen, took place with the defendant while her kids were trapped in the heat. Even those conversations did not make the defendant think, oh, I should probably go check on them. It is pretty hot. She heard the statements, and much like everything else she did that day, she ignored them as they related to her children. She ignored her children. She did not check on them, even though other people came in and were talking about how hot it was outside. Then you heard from Ms. Carrion, Isabel Carrion, Harmony's assistant. She told you that the defendant came in that day for a treatment to her buttocks area. You later learned it's referred to as a liquid BBL, a liquid Brazilian butt lift. Injections into somebody's butt to enhance the appearance. She's the assistant. After the defendant's procedure, she did not pay right away. She said she had to go to her car to get her phone. Some time had passed. Ms. Carrion was concerned that the defendant was going to leave without paying, so she went outside. Her car, her BMW, the white one in the photograph, was parked directly next to the defendant's. When she got to the car, she saw the defendant holding Amillio and moving him upside down. Not on the phone with 911, not giving CPR, not trying to get help, moving Amillio up and down in the car. This action, ladies and gentlemen, came after, from what you heard from Detective McNabb, that the defendant walked towards the business and then back out. Again, that might seem like a small piece of evidence, but think to yourself, she obviously started walking towards the business because she thought perhaps she could get help. And then realized, but then they're all gonna know that I have my kids with me. They're all gonna know that I left my kids in the heat in the car. That's not gonna look bad, or not going to look good, I apologize. So she turns around and walks back to her car. About 2 minutes later is when Ms. Carrion comes out, sees her in her car, tells her, you need to go get help. Your baby is not okay. At that point, she goes inside, subsequently comes back out and calls 911 at 4:40 p.m. 6 minutes passed in that time period, ladies and gentlemen. Think about 6 minutes and how long 6 minutes truly feels. And you're going to see how long Amillio sat there again without getting the help he needed while his mother, his protector, was trying to figure out how to cover up her actions. You heard from Ms. Carrion that the defendant was not showing any urgency, was not screaming, was not asking for help. Ms. Carrion only knew Mateo was in the back seat because she saw him due to the rolled down passenger side window. The window that was only rolled down after the defendant went back outside. The defendant did not tell her, help my other baby. She just took off with Amillio inside. Isabel saw Mateo in the back seat. She described Mateo as too hot. His skin was red, and flushed all over. He was weak and drenched with sweat. She also described the inside of the car. She initially said that it was hot, very hot. And then she agreed that she had actually told Ian, and I apologize for my language, ladies and gentlemen, but she had told Ian that when she reached her hand in the car to get Mateo, the inside of the car was hot as hell. Compare that statement, ladies and gentlemen, to the defendant's description of inside the car during her interviews with detectives. Compare that, the statement of Ms. Carrion, who has no reason to embellish, no reason to exaggerate, to the defendant who said, I was pretty comfortable. When you know, ladies and gentlemen, that there's no way, shape, or form that vehicle could have been comfortable at that time. Ms. Carrion told you that when she got into the car to get Mateo, the car was not running. The air conditioner was not on. Those also contradict the defendant's statements. And again, ladies and gentlemen, and I will encourage you, when you are considering what statements are credible, what statements to give the most weight to, take out Calcrim 226. Put that on your desk while you're thinking of the witnesses. And ask yourself, well, did Shelby, Ian, Harmony, who we'll get to in a second, Isabel, did they have any reason to lie? Did they have any reason to exaggerate?
All right, let's get a break, but first, Marie Pereira, watching along, your thoughts on this close from the state of California?
I think the prosecutor is doing a good job, but I think it could go either way. She keeps talking about implied intent, which is basically intent inferred from the conduct of the defendant. But that could cut both ways. I would look at the totality of the circumstances if I was on the jury, and I would say, what was her intent? To recklessly have her children be put in that position? I would say no, because she turned the AC on, she left them with food in the car, and in her mind, the car was not hot. So her intent is inferred by her conduct. And the mere fact that she left them in a cool environment says that she was not intending to purposely to hurt her children. So I think she needs to be careful about the way she's delivering it, because the intent could go either way when the jury looks at the totality of her circumstances, her actions before, during, and after.
Yes, and we'll have that side of it, I'm sure, from the calm, mild-mannered defense attorney who delivered a very powerful opening statement. I suspect it'll be that same tenor when he gets his opportunity to speak on behalf of Maya Hernandez. Marie, thank you. As always, we're going to get a break. When we come back, more of those closing arguments in Bakersfield, California, plus Los Angeles. Expecting an update in just about an hour and a half from the district attorney of Los Angeles. Rob and Michelle Reiner are dead. Their son, Nick, is facing double murder. He has a new lawyer, Alan Jackson. The very latest this afternoon here on Court TV.
Tonight on Closing Arguments, a deadly shooting at Brown University and a killer at large. Court TV's Matt Johnson is on the ground with the very latest.
Closing Arguments with Vinny Politan. Tonight at 8/7 Central. Only on Court TV.
These are the cases that captivated the world.
Couldn't keep my life straight.
They were killed by their own children.
That challenged the legal system and ourselves. Court TV, Legendary Trials.
Breaking news in the death of Rob and Michelle Reiner. Later this afternoon, Los Angeles County District Attorney Nathan Hochman will be joined by Los Angeles Police Chief Jim McDonald to provide details about the case involving the murders of Rob Reiner and Michelle Singer Reiner. Earlier this hour, we heard from Nick Reiner's attorney, Alan Jackson, that his client will not be in court today for medical reasons. Nick Reiner was expected to make his initial court appearance earlier this morning. Jackson told reporters outside the courthouse that he didn't know what the medical issue was, but he said Reiner will not appear before Wednesday at the earliest. That press conference is scheduled to begin 4 o'clock Eastern time. You can watch it right here on Court TV. Now, let's head back to Bakersfield, California. We're watching the closing arguments for the mom allegedly who left her child, well, she left her 2 kids in a hot car while she was getting butt filler. The defense here says this is absolutely a crime and she should be convicted, but not of second-degree murder. Second-degree murder is what the state of California wants, and that state prosecutor is delivering her closing argument.
They have any bias or interest in this case? Those are things that are outlined for you in 226. Things that you get to consider. And the answer to all those questions is going to be no. These are people who did not know the defendant until that day. They didn't know her before, they don't know her after. They were there for some cosmetic treatment and really ended up in a horrible situation. A horrible situation that is probably going to impact their entire lives. So when you are looking at what these people said and you're comparing it to what the defendant said, then ask yourself, well, did the defendant have reason to lie? Absolutely. Did the defendant have reason to downplay? Absolutely. Did the defendant have a personal interest in how the case is decided? Absolutely. Does the defendant have a bias in this case? Absolutely. You take those two statements, you take the inconsistencies, and when you use those with Calcrum 226, you are going to find that you have to believe and give credence and credibility to Harmony, Isabel, Shelby, and Ian long before the defendant. You heard from the nurse, Ms. Pacheco. She explained to you that she is an aesthetic injector. She provides cosmetic procedures to help enhance appearances. These procedures are not medically necessary. Certainly the procedure that the defendant was receiving that day, the liquid Brazilian butt lift, was not medically necessary. These are things to make people feel beautiful. They are elective chosen procedures. She told you that the defendant's procedure took about 15 to 20 minutes. That's consistent with what you saw in the video surveillance. She told you that during the morning hours of June 29th, 2025, she told the defendant that she could bring her kids in. You saw those text messages, ladies and gentlemen. You have them with you in the back if you want to look at them again. That conversation, you know, from both the defendant and from Ms. Pacheco happened before the defendant left Visalia that day. Ms. Pacheco told you that the defendant told her she had to go get her phone from her car because she left it in there because it was dead. The defendant told you that was a lie. That was not what she told Ms. Pacheco. So again, ask yourself, what reason did Harmony have to make that up? Absolutely none. And also look back at her testimony and consider how that testimony came out. She didn't come in here and say, yeah, she said it was dead and that's why she went out and now I know she's lying. She actually couldn't remember right away if that is what the defendant said. She refreshed her memory with the transcript of the statement she gave on the date of the interview. She didn't come in here with any malice. She didn't have an agenda. She was just testifying to you what she saw and what she observed on that day. She saw the defendant then come back in with Amillio. Amillio was limp, purple, and foaming at the mouth. Again, common descriptions throughout, ladies and gentlemen. When she saw Amillio, she told the defendant to call an ambulance because it was clear that he was not okay. And shortly after that, she saw Isabel come inside with Mateo. She said Mateo looked very hot, was hot to the touch, and his heart was beating really fast. This is an important statement, ladies and gentlemen, especially in light of what you heard yesterday from Dr. Thomas Riley. Harmony Pacheco, a registered nurse, told you that she felt Mateo's heart rate and it was beating really fast. Yesterday, Dr. Thomas Riley testified. He testified in the context of Amillio. He was a doctor for Amillio. But he also told you that hyperthermia, one of the things that happens when somebody's body is going through that, is their heart begins to beat really fast, essentially until it gives out. So you know that this statement is consistent with what could have been happening. And that Mateo might not have been as bad as Amillio, but he sure was on his way had he not been caught when he was. Based on Mateo's appearance, she took him to the bathroom where she put water on him. She then started putting wet cloths on his body to try to cool him down because he looked like he was going to have a stroke. His bottle, I apologize, was empty and appeared that it had old milk in it, so she had Isabel rinse it out and put water in it. Again, ladies and gentlemen, you know it was old milk because the defendant testified in court and told detectives that she had left each child with 1 bottle of milk. 1 bottle of milk for 2.5 hours, including the drive from Visalia to Bakersfield. Then text messages, you'll have those in the back with you. They just confirm the conversation. Then you heard from Nurse Gabrielle Long. She was the treating nurse to Amillio. She told you that Emilio's temperature was 107 degrees when he came in on June 29th, 2025. And ladies and gentlemen, I want you to consider something very important when you think about the testimony of Gabrielle Long, Elizabeth Bond, and Dr. Thomas Riley. These are medical professionals who, by their own testimony, see emergencies all day, every day. Not a single one of them had to come in here and reference any documents as to this incident. Not a single one of them had issues remembering Amillio or Mateo from that day. You heard Gabrielle Long tell you that she had never seen a temperature that high in her career. She also told you that Emilio's temperature was likely higher when he was in the car before he had been exposed to the airflow outside, exposed to the air conditioner in the ambulance, and transported into the hospital. Nurse Elizabeth Bond, she provided treatment to Mateo. She came in here and told you that Mateo was fine. He was responsive, he was okay. The one thing she noticed that was interesting to her was that Mateo was very clingy to the hospital staff. And she said, this is weird because most children don't want to be around us. Most children go away from us. He was clingy, he wanted to be held. He wanted to be comforted. And why is that, ladies and gentlemen? Because that day, just before he met Elizabeth Bond, he had been abandoned. He had been abandoned by his protector, by the person that's supposed to protect him. He sought out comfort in strangers because he didn't get that from his mother. She explained to you that the difference between Mateo's temperature and Emilio's, again, can be explained by their age, the body's ability.
All right, we need a break. We'll get you back into the Bakersfield courtroom when we return, plus the latest on Nick Reiner. Stay with us. Back after this.
Welcome back to Court TV Live. I'm Michael Ayala. We begin this hour in California, where Nick Reiner was expected to make his first court appearance today, but didn't show up due to medical reasons. Now, this is word from his defense attorney, Alan Jackson. That's right. We know him as the man who successfully got Karen Reed acquitted in her first murder trial. And Jackson told Court TV's own Matt Johnson earlier today that he is now representing Nick Reiner. And yesterday, the Los Angeles Police Department released a statement saying that the 32-year-old is, in fact, quote-unquote, responsible for the deaths of his parents, Hollywood director Rob Reiner and Michelle Singer-Reiner. The couple was found stabbed to death inside their home on Sunday. Now, before we hear more on the ground there in Los Angeles, here's a closer look at the details of the case. Sunday, December 14th, around 3:30 p.m., Los Angeles firefighters responded to a 911 call at the Brentwood home of Hollywood filmmaker Rob Reiner and his wife, Michelle.
Upon arrival, they determined that there were 2 deceased individuals inside of the residence.
Rob Reiner, the son of comedy legend Carl Reiner, catapulted to fame in the 1970s as Michael Stivic, Archie Bunker's hippie son-in-law on the hit television series All in the Family.
All right, put it there.
He went on to become a prolific director of such films as This Is Spinal Tap, Stand By Me, and When Harry Met Sally.
I came here tonight because when you realize you want to spend the rest of your life with somebody, you want the rest of your life to start as soon as possible.
Reiner and his wife, Hollywood producer Michelle Singer-Reiner, were found in their home fatally stabbed. The Reiner family confirmed the deaths in a statement posted on Variety.com. It is with profound sorrow that we announce the tragic passing of Michelle and Rob Reiner. We are heartbroken by this sudden loss, and we ask for privacy during this unbelievably difficult time. The Reiners married in 1989 and had 3 children together, sons Jake, Nick, and daughter Romy. Nick Reiner has spoken openly through the years about his issues with drug addiction and homelessness. In 2016, he appeared in this clip, currently circulating on social media, with his father. It was a panel discussion promoting the movie Being Charlie, which was partially inspired by Rob Reiner's experiences parenting Nick.
The whole process for me, I can just speak for myself, it did make me understand him a lot more, and I think it made me a better father. Hopefully it did. If your kid is going through rough times, you know, the parent is, your main job is to keep your child safe.
As police, media, and onlookers converged on the home, sightings were reported of Reiner's friends and collaborators, Larry David and Billy Crystal. Tributes poured in from Hollywood and beyond. Carrie Elwes, who starred in Reiner's cult classic The Princess Bride, posted no words. Jerry O'Connell was one of the child actors featured in Stand By Me, and he tweeted, "Love you, Rob, sincerely." Former President Barack Obama wrote in part, "Beneath all of the stories he produced was a deep belief in the goodness of people and a lifelong commitment to putting that belief in action." All right, joining us now is Court TV field reporter Cody Thomas. Cody, all right, you're on the scene there. Give us the latest.
Yeah, Michael, well, no arraignment looking likely for today. Of course, another media frenzy here at the courthouse, awaiting what we thought was going to be an arraignment, but according to officials here at the courthouse, not looking likely. There's still a possibility later on, but as of right now, the DA has not filed official charges against Nick Reiner, but we have gotten word that there is a press conference later on today, so we could see those charges then. As we know, the DA has 48 hours to officially file those charges against Nick Reiner. But we have confirmed the big blockbuster news here today. Nick Reiner has hired Alan Jackson as his defense counsel. Of course, we know Alan Jackson from that monumental Karen Reed murder trial and retrial. Most recently, the case against Frazier Bohm out in Malibu. Very high-profile attorney, of course. Now, Jackson says his client, he told reporters today that his client, Nick Reiner, will not be in court before Wednesday due to that medical issue. Now, our sources, again, this is our friend to our network, Philip Dubé, let us know today that Nick Reiner is housed in the medical unit of the Twin Towers Correctional Facility, which is a medical unit within the jail's psych hospital. He could be deemed a medical miss-out to court depending on his medical status and suitability for transport to court. So that's what was holding up the arraignment here today, Michael. We might see one later on this week. But just to walk back through a couple steps of the investigation here, Michael, you know, according to the New York Post, Nick Reiner, following those horrific stabbings, he checked into a hotel in Santa Monica around 4 a.m. on Sunday following the stabbings. Police say when they got there and searched that room prior to his arrest, it was covered in blood all throughout the shower. There were bed sheets over the windows, and then he was eventually arrested about 15 miles away toward South Central L.A. from that Brentwood neighborhood where his parents, Rob Reiner and Rob's wife, Michelle, lived and were eventually found murdered. Now, all of this horrific acts, this stabbing, this all comes after that argument, alleged argument at Conan O'Brien's house party at his Los Angeles home. No word on exactly what that argument could have been about. Michelle Reiner was also in attendance there, Nick Reiner's mother, but there is suspicion that that argument was about Nick's refusal for another cycle of treatment for his drug addiction after a whopping 17 stints in rehab, Michael. So clearly this young man had some real problems with drug addiction. He had problems with homelessness early on in his teen years. So, you know, again, Rob Reiner, a pillar of Hollywood, directed Misery, directed A Few Good Men, directed The Princess Bride, you know, an outpouring of mourning, not only here in Los Angeles, but across the world.
All right, Cody Thomas, thank you so much for that report on the ground there in Los Angeles. Right now, I want to welcome in our guest to talk about this a little bit with us, National Trial Attorney Michael Jaffer. And Michael, again, the big news today, Alan Jackson joining the case. I want to get your thoughts on that. For me, it suggests a couple of things. One, I think they intend to put on a vigorous defense. You wouldn't hire Alan Jackson unless that was the case. And also, there must be still family support for Nick, because clearly Alan Jackson doesn't come cheap. although we know he will step in from time to time and do things pro bono. Don't know if that's the case here. But clearly it seems the family is still supporting Nick under these difficult circumstances.
1,000%. This is definitely not one of the cases that Alan Jackson would take for free. This is a case that he's being retained. In this situation, the way I see it is attorneys take cases, some cases you take pro bono because you know you're going to have a big spotlight. Some cases you take and you get retained and you get paid. This is not the case you take pro bono. He's got his spotlight. He's taken a case. We've seen him all over TV for the last 2 years. He's definitely being paid for this case. At the end of the day, this is a good hire. This is Alan Jackson's backyard. So I expect him to do an amazing job on this case. I'm really curious to see what the defense will be.
Well, that raises my next question. With the addition of Alan Jackson, you're thinking about defenses. What are some possible defenses in this case?
All mental health. All the defenses here are mental health. There's no other defense other than mental health. People don't understand how big of a deal mental health is, and I would expect a person like Alan Jackson to properly lay out the mental health defense. He's going to have a sympathetic jury. West Coast juries, I'll tell you what all of us lawyers talk about. West Coast juries are more amenable to mental health defenses than East Coast juries or Southern juries. So that's what I expect the defense to be, and we'll see what happens.
Now, Nick is the son of a celebrity. I don't know if he's so much a celebrity. The victims are the celebrities, so celebrities certainly going to play a role. But what type of role do you think it'll play in this case?
I think it'll play a big role because the juries in that case are going to be juries who are accustomed to seeing celebrities and working with celebrities.
Looks like we might have lost Mike there for a second. I cannot hear him at all. So what we're going to do here is, again, I think he was just talking about, celebrity always, is something that LA juries are used to. But my issue would be, because the celebrities are such popular victims, could that work against him? Sometimes celebrity can work for you if you are the celebrity. Not the case in this case. All right, what we're going to do here, we'll step aside. We'll take a break. When we come back, we're going to head back to our live trial. That's also happening in California for defendant Maya Hernandez. Now, she's the mom charged with leaving her son to die in a hot car death while she was getting a Brazilian butt lift. All right, stay with us. We'll be right back.
Tonight on Closing Arguments, a deadly shooting at Brown University and a killer at large. Court TV's Matt Johnson is on the ground with the very latest.
Closing Arguments with Vinny Politan, tonight at 8/7 Central, only on Court TV.
'Tis the season for true crime. Each morning we'll dive into a case that took place around the holidays. Join us for the 12 days of holiday crimes.
Opening statements with Julie Grant. Mornings at 8/7 Central on Court TV.
All right, folks, now back to California, where closing arguments are underway in the trial for Maya Hernandez. She's charged with murder after allegedly leaving her children in a hot car while she was at a spa appointment. Now, her 2-year-old survived, but her 1-year-old died at the hospital. The defendant took the stand on Monday, testifying that she believed the boys would be safe inside the vehicle and didn't expect the car to shut off while it was parked. Hernandez told jurors it was not until after the incident that she began to fully understand the consequences of her decisions. Let's head back into court now, where the prosecution is giving their closing argument to the jury.
Release sweat to regulate its temperatures as the body gets older. Dr. Thomas Riley, you heard from him yesterday. He's been an emergency room physician for 30 years. You saw how he testified, ladies and gentlemen. When he was talking about Amillio, there were times when he appeared he was going to get emotional. He talked about the lengths they went through to try to save Amillio. That Amillio suffered from cardiac arrest in the field. When he came to the emergency room, he was intubated and they were doing resuscitation efforts. When Amillio arrived, he was pale, ashen, cyanotic, meaning purple or hypoxic, not getting air. No oxygen flow to his body. Amillio was literally lifeless, is a quote from Dr. Riley. Literally lifeless. He and other ER personnel attempted life-saving measures for at least 40 minutes. When Amillio arrived, his temperature was 107 to 108 degrees. They took steps to cool him down, including ice packs all over his body and a cooling IV. He described these as being as aggressive as they could to try to save Amillio. He told you that a temperature of 107 is not compatible for life. Someone cannot live. A body cannot sustain that temperature. Heart rate fluctuation caused by temperatures cannot sustain life. Dr. Riley explained to you that being exposed to extreme heats for an extended period of time causes the organs in the body to be impacted, causes a chemical breakdown of the cells. And he described to you that when this organ failure is happening, this breakdown of the cells is occurring, that person experiences these things. The person going through this begins to have an overwhelming sense of heat. They may begin to become overwhelmed and hyperventilate, feel like they are suffocating. He said this person can feel like they are being strangled, all from being exposed to the heat. He also told you that Amillio had signs of rigor mortis, stiffening of the muscles in the body as a result of the body shutting down. And that rigor mortis typically begins to set in within 1 to 2 hours. Amillio's organs and his body had already shut down at least 1 to 2 hours before Dr. Riley had ever seen him. Probably the most important sentence you heard from Dr. Riley: early intervention could have saved his life. Early intervention could have saved his life, ladies and gentlemen. And there is one person in this world that could have gotten him the early intervention. One person that knew he was in the car. One person that had a legal duty to him. One person that was obligated to check on him and get him that early intervention. The defendant, by simply going to check on Amillio, could have prevented all of this. But she, again, chose not to. Early intervention could have saved his life. But the defendant did not allow for that to happen. He told you how heartbreaking it was to see Amillio, how gut-wrenching it was when they could not save him. And then you heard about the recreation. Again, kind of like the video surveillance, detectives wanted to ensure they took steps to make this as thorough as possible. And Detective Barthelmess, well, we don't know what was happening that day. We don't know how it felt inside the car. Let's try to find out. Let's simulate that day as best as we can. So they looked up temperatures. They found a date that had temperatures almost identical, at times identical, to the date of June 29, 2025, and that was July 2nd. They got the car, they ran the car for an appropriate amount of time. They took the defendant's car to 31 South Real Road. They parked the car in the same exact parking spot and made sure to arrive in the parking lot at the same time the defendant arrived. And ladies and gentlemen, it's also important to keep in mind that during this recreation, you were informed, you were told they did the recreation in a light most favorable to the defendant. They took her for her word at what she said she did that day. And they did the recreation as such, which meant they stayed in the car for a little while. They used the same times. They used the same parking space. They ultimately got out of the car at about 2:09, shut the doors, locked everything up, and left the car. They left the car with thermometers that had been appropriately calibrated, thermometers that were working, and body-worn cameras to capture the temperatures inside of the car. You also heard that at 4:08 p.m., Detective Jordan's body-worn camera shut off. Could not record anymore. At 4:16 p.m., Detective Barthelmess's camera, which was on Amillio's seat, shut off at 4:16 p.m. Both of those cameras gave the same notice: critical internal temperature. The car got too hot for an electronic device. It was too hot to sustain an electronic device while Amillio and Mateo were still strapped inside of it. You have Exhibit 75, and that is the item that was judicially noticed by the court, that the temperatures in Bakersfield on June 29th, 2025 at 2:54 p.m. was 101 degrees Fahrenheit. At 3:54 p.m., 102 degrees Fahrenheit. And the high temperature that day was 102 degrees. The high temperature that day occurred while Amillio and Mateo were inside of the car. The temperatures in Bakersfield on July 2nd, 2025, the date of the recreation, 2:54 p.m., 101 degrees. Identical to the date of June 29th, 2025. The temperature at 3:54 p.m. on July 2nd, 2025, 101 degrees. 1 degree cooler, actually, than the date of the actual incident. The high on July 2nd, 2025 was 101 degrees. And again, we just went over this, the steps that the detectives took to make the recreation as identical, as similar to the date and issue. Rolled up the windows, shut the door, left the AC running as the defendant described, and that is a setting 4 out of 7 at 60 degrees. With one air vent in the car, ladies and gentlemen, an air vent that the defendant told you was only in the front of the car. Now, I say they did it as the defendant told them because I anticipate, and you have heard, there is statements from the defendant that she left her air conditioner running, that she left her car on. And I urge you, ladies and gentlemen, to accept those statements with caution. Take those statements in light of CalCrim 226. And recognize that although the detectives considered that information in doing the recreation, that is not indicative that they were taking that statement to be true. They were simply conducting the recreation in a light most favorable to the defendant. You do not have any independent evidence that that air conditioner was left on or how it was running at the time. The only evidence you have of any air conditioner came from the defendant, and we'll discuss that in a few minutes. Detective Barthelmess specifically told you the questions they wanted to answer with the recreation. Does the engine shut off after an hour as indicated in the owner's manual? The owner's manual that the detectives bothered to look at, but the defendant never did. The defendant specifically told you she never looked at the owner's manual, doesn't even know if she ever had one. That was in her testimony on.
All right, prosecutors reminding this jury of the ugliness of this crime as they ask for a second-degree murder conviction for Maya Hernandez. All right, we'll take a break here. Coming up, we'll have more closings in the cosmetic filler child killer trial for Maya Hernandez. Plus, the search for the Brown University shooter continues. Court TV's crime and justice correspondent Matt Johnson joins us live from Brown University next with the latest on the investigation. Keep it here on Court TV.
Done.
Welcome back to Court TV Live. I'm Michael Ayala. I want to get you back to Bakersfield, California for more of the cosmetic filler child killer trial for Maya Hernandez. She is accused of leaving her 2 children alone in a hot car 4 hours while she went to a med spa appointment. Now, one child did survive, but her 1-year-old son died from the heat. Right now in the courtroom, the state is giving their closing argument. Let's get back in for more.
That was in her testimony on drug examination. That could have provided her some useful information when she chose to leave her kids in the car. But she didn't care. What was the internal temperature of the vehicle when defendant left Mateo and Amillio inside of the vehicle? If the vehicle does shut off after an hour, how long does it take the internal temperature to rise? What is the maximum temperature inside of the vehicle once the vehicle is shut off? How long were Amillio and Mateo exposed to these temperatures before defendant returned to the vehicle? And guess what, ladies and gentlemen? They got answers to every single question they had. The car did, in fact, shut off after 1 hour, as indicated in the owner's manual. Even with the air conditioner set as described by the defendant, the coolest Amillio seat ever got was 80 degrees. And that's because by her own statement, if to be believed, she left it on the middle setting with an air vent only in the front seat. The air wasn't circulating to the back seat. Amillio and Mateo were exposed to temperatures of over 100 degrees for over an hour before the defendant returned to the vehicle. Amillio's seat reached ambient temperatures of 116 degrees. And I say ambient temperatures, ladies and gentlemen, because that is the temperature that came off the thermometer that was essentially hovering in the middle of Amillio's seat. But you heard from Detective Chad Ott that the temperature in Amillio's seat as he was sitting in there was likely significantly higher due to his body being in the seat and his body heat going into that area. Temperatures inside the vehicle, again, ladies and gentlemen, you have this. You'll have it in the back with you. It was testified to, and it is part of the video surveillance. But the car hit 100.5 degrees at 3:25 p.m. By 3:30, had jumped to 103 degrees. By 3:35, had jumped again to 105.2 degrees. By 3:40, had jumped to 107 degrees. By 3:55, jumped to 110.6 degrees. 4:05, 112.4 degrees. 4:15, the last recorded temperature by body cam camera before it died because of the heat, 114 degrees. And the temperature when detectives opened the doors at 4:33 p.m. was 116 degrees. You'll have the photos of the thermometer. You'll have the video of the temperatures rising. You saw it in court. It was boring. Some might even describe that as painful. But you know what, ladies and gentlemen? You got to watch those temperatures rising in the air-conditioned courtroom. Amillio and Mateo experienced that in real time. They experienced those temperatures rising with nowhere to go, nowhere to escape. You got to have the air conditioning, your bottles of water. I believe we even interrupted to take a short break at one point. Consider how painful that was to watch. And Amillio and Mateo had to experience that in real time. You heard from Detective Chad Ott. You heard about his background, his science. He told you about studies he's participated in, studies he's read. Studies he's read in relation to recreations in babies left in hot cars. And he actually told you that he found the results of Detective Barthelmess's recreation to be quite favorable to the defendant. And he said that based upon the studies he read. For example, one study had to do with temperatures, external temperatures outside of 73 to 93 degrees. And the internal temperature of that car rose to 135 degrees, ladies and gentlemen. Detective Ott told you that the manner in which the recreation was conducted was scientifically sound, that it was done in the way to best achieve the most accurate results. And he even told you that he was quite impressed by the amount of effort that had been placed into recreation. He was impressed by the steps the detectives took and thought about to make this recreation as accurate as possible. And then again, the video surveillance. Ladies and gentlemen, we sat through that video surveillance. About 2 hours in court. There wasn't sound, there wasn't talking. Almost the entire time, we watched the defendant sit in one single chair. Again, it was boring, We might even call parts of it, most of it, or all of it painful. But again, ladies and gentlemen, you experienced those 2.5 hours in the comforts of an air-conditioned courtroom. Amillio and Mateo, they experienced those 2.5 hours trapped inside of a hot car during the hottest time of day. And I say trapped because they had no way to get out. They had no means to get help. They were trapped in an inferno, ladies and gentlemen. So yes, it was painful to sit there for 2 hours, but you had water, you had air conditioning, you had airflow throughout the courtroom. Amillio and Mateo did not get that same courtesy from their mother. And this is just a kind of a combination of the video surveillance with the recreation, where you can see the defendant sitting inside the business.
All right, we're going to pause closing arguments right there for a moment to get an update on the search for the shooter at Brown University in Rhode Island. Over the weekend, the gunman opened fire at the Ivy League school, killing 2 students and injuring 9 others. Now, it has been 4 days, and investigators still haven't caught the suspected shooter. But a person of interest was taken into custody over the weekend, but that person was released. Court TV's crime and justice correspondent Matt Johnson is live right now at Brown University with all the latest. Matt?
Michael, this manhunt has intensified. We're now in day 4 of the search for the shooter after this deadly attack here on Brown University campus, taking place here at the engineering building right behind me. I'm with Peter. He's going to show you the front door and the area where the focus has been. There has been a larger police presence here on campus since Court TV arrived several hours ago. You can see just at my feet, there's also this crime scene tape, because what we're looking at over here, this is the command post for not only the FBI, but also the local police that are assisting in this investigation. I want to show you the very latest, which is these new images just released to Court TV and other media. This is coming from investigators, FBI focusing on this man, considered a person of interest right now. So they have several angles of surveillance video, ring video that have been released from this area just moments before this attack took place on Saturday here at the Barris and Hawley building, the School of Engineering. The suspect described as approximately 5'8" with a stocky build. Moments ago, police updated us that they are still searching for this person. Anyone with information, call police. But here's what they told us not too long ago. Here's a bit of a news conference. Take a listen.
We want to make sure, as the governor stated and the mayor stated, to make sure that we identify this individual and bring him to justice. Our work that initiated today and continues to initiate for a while, since it started, we're at the 49th hour, and there's no one that wants to put this individual in handcuffs than us. So this has brought us to a new lead, which I momentarily probably will be able to provide you with. It's going to include video of this individual, as well as photos of this individual. We're asking the public for assistance to be able to identify this individual.
There are several tip lines in place right now, one with Providence that has been bannered all over the school. And then, of course, the FBI, which is assisting in this investigation. A lot of boots on the ground. It's 1-800-CALL-FBI with any tips. And FBI also including a $50,000 cash reward with information leading to an arrest. But again, they are searching for that suspect. We have information on our website. Just look at courttv.com, Michael.
Now, Matt, you are there on campus. Have you been able to get a sense of what the mood is like there on campus?
Right, it should be a jovial time. There were holiday parties planned over the weekend, and then this deadly shooting took place. Students, they are still trying to go about their day before the holiday. They say that they feel rattled. There's a growing memorial, hundreds of flowers being dropped throughout the day for the students that lost their lives, which we'll talk about. We want to focus on the victims. And then there is such a large media presence here on Brown University campus. There is national media, some international, and then, of course, local local media, trying to bring the latest information and also help and assist authorities in finding this suspect. I spoke with a student not too long ago. Earlier today, she works at this building where this deadly attack took place. Here's her thoughts.
It was really scary, too, because I live like 7 minutes away from this building, too, and I work in that building as well.
You work in the building where it
I work in the basement of Ferris and Holly, so it was, so like now our whole like office area is like a crime scene, and like I can't imagine going into a building where like so many kids were traumatized and hurt.
She is traumatized like so many others. Now let's focus on the victims. 2 people losing their lives in this deadly attack. 9 others still recovering. But the 2 people that died, Ella Cook, she was a sophomore, Republican club here at Brown University, also part of a society and Alpha Chi Omega sorority sister. And then the gentleman who died, Mohammed Aziz, he was in his first semester, U.S. dual citizen with Uzbekistan. He was a biochemistry major. He had dreamed of helping other people, including survivors of attacks like this. He wanted to become a doctor. Both described as both being, quote, brilliant and beloved members of the college campus here at Brown University in Providence, Rhode Island. Again, there is going to be a vigil focusing on those victims and the survivors tonight at 7 p.m. here on campus, and Court TV will be there. I'll send it back to you, Michael.
All right, Matt, thank you so much for that report there from the campus of Brown University in Rhode Island. And folks, as he mentioned, any information at all, please call 1-800-CALL-FBI. And also, you can go to our website and get some information as well. All right, we'll take that break now. When we come back, we'll have more closing arguments in the murder trial for Maya Hernandez. That's in California. Stay with us.
Coming soon to Court TV.
The Microsoft executive gunned down.
Now his ex and her new husband are charged with his murder.
I'm gonna kill her.
An alleged murder plot involving a family's au pair and the married father she worked for.
A social media sensation, now a suspected killer.
Why do you have something against me?
She wrote a children's book about her husband's death. Now she's accused of killing him.
The high-stakes trials you don't want to miss. Coming soon, only on Court TV.
Donor.
Right, folks, back to California for more of the cosmetic filler child killer trial for Maya Hernandez. Hernandez is charged with murder and child cruelty after leaving her 2 young children alone in a hot car while she went to a med spa appointment for a BBL, or a Brazilian butt lift. Now, her 1-year-old son, Amillio, died. The other child, her 2-year-old son, survived. Now, before I take you back in for more of those closing arguments, I want to bring in our guest for this hour. Still with us, trial attorney, national trial attorney, Michael Jaffer. Michael, I want to know where you fall on this one. The defense has already said, look, we concede involuntary manslaughter. Basically, a child died during the commission of a misdemeanor, which was leaving the kids in the car. The state wants this second-degree murder, and in their closing arguments, really honing in on the horribleness of the death, of the crime, of the actions of the mother. Where do you kind of fall on this one?
The outcome bias in cases where a kid dies is very, very intense. The jury will backfill recklessness. They'll unconsciously backfill recklessness. So in my opinion, you have a burden as a defendant when a child dies. I don't care what the Constitution says. You have a burden. Your burden is to prove to the jury that you yourself were not reckless, you were not malicious. It's a high burden, but that rests with the defense. Not legally, not constitutionally, but effectively.
Now, Mike, do you think it makes a difference? As I think about this case, I wonder if it makes a difference. What if she had been going in for, let's say, a root canal, as opposed to a Brazilian butt lift, right? I mean, when you think about what she was doing and the fact that it was really this sort of selfish pursuit, I think it makes a difference in how this jury will look at the facts of the case.
1,000% agree. Let's just say the same exact facts, but one difference. She was going in there because she had a 3rd kid, and the 3rd kid had an emergency. She was taking him to the pediatrician, but everything else was the same. She would not have even been charged. So yes, you are right. That is absolutely the jury's going to backfill intent, and that's going to be one of the elements they're going to use to backfill intent. You were getting a Brazilian butt lift, so that is absolutely going to damn her in the eyes of the jury.
Yeah, conscious disregard for human life. That's what they have to find for that second-degree murder.
Yeah.
Oh, Mike, stand by. I want to take folks back into court now for more of the state's closing argument.
Chatting, engaging, laughing, smiling at different times when her vehicle is 105.2 degrees outside, 107 degrees outside, sitting there, legs crossed, arm on her chin, not a care in the world. Her car with her 2 children is 107 degrees, best case scenario at that time. 108 degrees, still sitting there chatting, not a care in the world. 109.5 degrees, still sitting there, legs crossed, chatting, looking at the other patrons, having a conversation. 110.6 degrees, still sitting in the same chair. Cool. Access to the bathroom, water if she needs it, talking to the other patrons. 111.5 degrees, bent over, engaging in conversation, sitting in the same chair. 112.4 degrees, still just sitting there, chatting, perhaps talking about their BBLs, their 4th of July plans, while her kids are burning in her car. 113 degrees is when she essentially gets up. She doesn't leave. She's gone from that chair. But at this point, she goes back into the treatment room. Down the steps, down a hall, down another hall. Still in the business. When her car's getting up to 114 degrees. She starts walking out at 4:33 p.m. She's walking out of the air-conditioned building while her car is a temperature of 116 degrees. And she's walking out not to go check on the kids, but to go get her phone to pay for her treatment. You heard Dr. Glineski testify about the autopsy. He performed the autopsy of Amillio. This autopsy took place on July 5th, 2025. And he explained to you that Amillio had edema, or commonly referred to as swelling of the brain. The brain swelled, and it continued to swell and swell until it began to shut down. The shutting down of the brain caused the rest of the organs to begin to shut down. He also told you that somebody going through this edema, swelling of the brain, can feel it within their body. They experience it. This is not a quick death, ladies and gentlemen. This is a slow, painful death where the person begins to feel lethargic. They begin going limp, perhaps unable to speak. They lose the bodily functions. They may urinate, may defecate on themselves because the organs preventing all of that are no longer working. This person might start having seizures and will likely show foamy secretions, all things that were present with Amillio. Dr. Glineski explained to you that the body begins to shut down at 104 degrees. But when Amillio arrived to the hospital at 5:00 p.m., his temperature was 107 degrees, which is probably lower than it was in the car. Amillio's body began shutting down a significant amount of time before he was found by his mother or by the ambulance personnel. Dr. Glineski, in addition to Dr. Riley, told you that it is impossible to survive a temperature of 107 degrees. Dr. Glineski, impossible to survive. Dr. Riley, that temperature is not compatible with life. The cause of death was hyperthermia, commonly referred to as heat stroke. And this is where his testimony got interesting, ladies and gentlemen. He told you that he initially, and he wrote on the death certificate, that the manner of death was an accident. But he explained to you why he made that finding. And he said, I hate making findings like this because I have to do it based upon just a little bit of information. Just the information that his investigator provides to him. He told you, I was 50-50 on accident versus homicide. And again, ladies and gentlemen, it's important to recognize and consider these are medical terms. Medically an accident, medically a homicide. This is not a legal term. It is not a legal definition for you to consider. You are the judges of whether or not this was legally murder, legally homicide. These are medical terms. Homicide meaning the death at the hands of another. He told you he didn't have enough information about the defendant's intent or mind state. He didn't have her recorded interviews. He wasn't able to watch those. And he told you that his opinion would likely change were he to find out that she knew it was dangerous and she did it anyway. He was 50-50 before he had information on whether or not the defendant knew the dangers and acted anyway. So he said accident, but he told you that this likely could have been a homicide as well, medically speaking. Now, let's talk about the defendant's interviews, ladies and gentlemen. You will have these interviews with you. You will have them in the back. You can watch them. And as you heard in opening, and as I told you today earlier, and you probably gathered through the course of the evidence, the crux of this case, the crux of your decision is going to be, what did the defendant know and when did she know it? Her interviews, both her first interview on June 29th and her second interview on July 3rd, give you those answers. She admitted to coming to Bakersfield, leaving the kids in the car, had the kids strapped in the car. Those items of evidence, ladies and gentlemen, are uncontested. Nobody's arguing those. Nobody's saying they didn't happen. But one thing she did say in her first interview was she did not know how long she left the children in the car. But you know, after watching the video surveillance and hearing her testimony, that she did know how long they were in the car. She knew how long she was in the business. She was wearing an Apple Watch. Between 2:27 p.m. and 4:08 p.m., she checked her Apple Watch no less than 45 times. She knew how much time was passing. She knew she wasn't just going to be in there for the quick 15 to 20 minutes. She knew that after the first 20 minutes. She knew that after the second 20 minutes. She knew that after an hour passed. And at 3:33, ladies and gentlemen, the nurse...
All right, folks, there's no mistake that this prosecutor's focusing in a lot on the suffering of these children, because I think she needs that to get this second-degree murder conviction. All right, we'll take a break here. When we come back, we'll have more closing arguments in the murder trial for Maya Hernandez. That's when we come back, so keep it here on Court TV, your front row seat to justice. Welcome back to Court TV Live. I'm Michael Ayala. Court TV is tracking several cases across the country this afternoon. In Ohio, it's now day 5 of the murder trial for defendant Paul Hicks. He's accused of killing his ex-wife, Regina. In Nevada, sentencing is underway for the 2 men who pleaded guilty to fatally striking a former police chief with a stolen car while he was on a bike. And in California, Nick Reiner did not appear in court today due to medical reasons. Now, he stands accused in the stabbing deaths of his parents, Rob and Michelle Reiner. We now know that he will be represented by defense attorney Alan Jackson. Also in California, we're watching closing arguments in the murder trial of Maya Hernandez, the mom who allegedly left her son to die in a hot car while she was getting a Brazilian butt lift. We'll take you back in now, where the state is delivering their closing argument.
Specifically told her there was still another person ahead of you. At 3:30, and almost an hour and a half of having been in the business, she knew it was still going to be probably another 40 minutes. And she continued to sit in that chair without any actions. She said in her first interview that she left her phone with her kids because they were watching TV. That she propped it up on the headrest so that they can see it while they were sitting in their chairs with their cookie, their 1 bottle of milk, and their candies. In her second interview, she tells detectives that she didn't bring the kids inside because they were sleeping and she didn't want to wake them up. So were they watching TV or were they sleeping, ladies and gentlemen? These might seem like small inconsistencies, but it's the inconsistencies that tell you whether or not she is being completely honest. Whether or not she's being completely honest with the detectives, and whether or not she was completely honest with you in court. She estimated she was in the waiting room for about an hour You know that's not true. She know that wasn't true. She admitted that she did not go to check on the boys at any time. She told you that when she went back to her car, the car was still running. You know from Ian's testimony that that's not accurate. You know from Isabel's testimony that that's not accurate. You know from the recreation that that is physically impossible. Isabel told you that it was hot when she got back to the car. It was not on. The AC was not running. It was hot to the touch. She told you that Amillio was hot to the touch, that Mateo's cheeks were red. That's what alerted her that something was wrong. Those statements, those observations are not consistent with her statement that her car was still running, that her air conditioner was still on. And she says, it sounds stupid for me to say, like, oh, like, I didn't mean for that to happen because, like, I did leave them, but I thought they were going to be okay. It sounds stupid for me to say. Why did she say it that way, ladies and gentlemen? It sounds stupid for me to say I thought they were going to be okay because I know better. It sounds stupid for me to say this because everybody knows better. Then she says that she knew her sister would probably say yes if she asked her to watch Mateo and Amillio, but she didn't want to irritate her. That statement was also different than how she testified on the stand. We'll talk about that in just a moment. Then she testified on the stand that her concern was not that the kids would be running around in the waiting room. Her concern was that they were sleeping. But in this first interview, just hours after the incident, ladies and gentlemen, about 8:25 p.m. on June 29, 2025, she says, Detective McNabb asks her, so your concern was they'd be running around the waiting room without you? She said, yeah. Your concern is they would be running around, which is why you didn't bring them in? Yeah. But now you know she had a way to prevent that. She had her stroller. She could have buckled them in their stroller. She did not ask about Amillio's condition until 30 to 40 minutes into the interview. Right as the detectives were telling her they were going to take a break, she asks about Amillio's condition. Why did she wait that long to ask? Because she already knew. She knew what she did. She knew before she did it, it was dangerous. And at that time, she knew everything had come full circle and the dangers she knew existed actually happened. She said that she knew that leaving the children in the car was a bad decision, acknowledged that her story about the air being on did not make sense when considered with all of the evidence, told Detective McNabb that what she did was irresponsible. She told Detective McNabb that she thought about the fact that it was irresponsible when she got out of the car and left the babies inside. She told you yesterday, ladies and gentlemen, that she didn't realize it was irresponsible until after the fact. June 29, 2025, 8:25 p.m., thought about the fact that it was irresponsible when she got out of the car and left the babies inside. That's implied malice murder, ladies and gentlemen. That's an admission to knowing it was dangerous and acting anyway. Detective McNabb, you know have you heard the radio ads about not leaving your kids in the car? I mean, a lot of cars nowadays, when you get out of the car, they tell you to make sure to check for your kids. Like it's, that's kind of an irresponsible thing to do. Defendant, yeah. Detective McNabb, I mean, do you know that? Defendant, yeah. Detective McNabb, okay. Did you think about that when you were getting out of your car? Ladies and gentlemen, these questions could not be more clear. Did you think about the dangers when you were getting out of your car? Defendant's answer, yeah. So this storyline that you heard yesterday, that she didn't realize it was bad, dangerous, or irresponsible until after the fact, you cannot believe that testimony, ladies and gentlemen. You cannot compare that testimony And her incentives to lie, her reasons to lie with the statements she made to Detective McNabb under completely different circumstances and believe her in court testimony. You cannot. It doesn't work. I mean, Detective McNabb, I mean, if you knew that and you thought about it, what made you think it was okay to leave him? I don't know. Well, ladies and gentlemen, if she was truly misunderstanding what Detective McNabb was asking her, as she wants you to believe, when he's asking her, what made you think it was okay to leave them, her answer is, oh, because beforehand I didn't realize it was bad. I'm sorry. I misunderstood you, Detective. I now understand it was bad. I now understand it was dangerous. I didn't realize you've been asking me about what I knew beforehand. That's not her answer. That was never her answer. And look at this recording. Consider this recording, ladies and gentlemen. She is not confused by the questions. She does not have to ask the detectives to repeat their questions. She understands what she's being asked and she answers them directly. And now we're moving on to the defendant's interview number 2. Some more statements that show you that this is exactly second-degree murder. Detective McNabb, but I do want to just talk a little bit about what you were thinking as this was going on, okay? There's a lot of talk in like, have you ever heard like the radio ads about not leaving your kids in the car? You have? Question mark. Watch the video. He says you have with a question mark because she's nodding her head. What did you think could happen if you do leave them? Like prior to this happening, did you understand? Prior to this happening, did you understand? Clear as can be as to the timing the detective is talking about, ladies and gentlemen. And I understand the circumstances are different, but what do you think could happen if you left your kids there? Defendant, what happened, I guess? Then he follows up. What happened with Amillio? Question mark. Did you know that prior to this happening? Completely unambiguous question, ladies and gentlemen. He does not say, do you know this? Do you know this now? Is this your current understanding? He says, did you know that prior to this happening? Defendant responds, I seen the news and stuff, but I didn't really think that would happen. I knew it can happen, but I didn't think it would happen to me. You saw the news? Like, have you seen news of this happening before? I mean, not actually, but I've heard people talk about it. Is there anything specific come to mind or just in general? Just in general. I knew this was bad in general from hearing people talk about it because everybody knows it's bad. This is information, ladies and gentlemen, that this day and age you cannot avoid. You cannot avoid knowing that leaving babies in a car can result in death. Everybody knows that. It's in the news media all the time. It's in ads all the time. Okay, did you think about that as you were getting out of the car? Again, another opportunity for the defendant to say, oh, you've been asking me?
You can't argue. It is well known that you don't leave your kids in a car, especially when it's very cold or very hot. But yet, according to statistics, still about 52% of these cases are people who are forgotten by their parents in cars. It just happens sometimes. All right, we'll see how the jury looks at it. We're going to take a break. When we come back, more closing arguments in the murder trial for Maya Hernandez. Keep it here on Court TV.
Tonight on Closing Arguments, a deadly shooting at Brown University and a killer at large. Court TV's Matt Johnson is on the ground with the very latest.
Closing Arguments with Vinny Politan, tonight at 8/7 Central, only on Court TV.
'Tis the season for true crime. Each morning we'll dive into a case that took place around the holidays. Join us for the 12 days of holiday crimes.
Opening statements with Julie Grant. Mornings at 8/7 Central on Court TV.
Welcome back, folks. We're going to go back now to Bakersfield, California, where we are watching closing arguments in the cosmetic filler child killer trial for Maya Hernandez. Hernandez is charged with murder in the hot car death of her 1-year-old son, Amillio Gutierrez. Her 2-year-old son was also left in the car, but he did survive. Let's get you back inside that courtroom now. We're listening to Prosecutor Stephanie Taconi give her a closing argument in front of the jury.
Asking me if I thought it was dangerous before I did it? Let's back up, Detective. I thought you were just asking me about if I knew it was dangerous now. This is yet another opportunity for her to say, oh, I've been misunderstanding you. But she doesn't, because she knew exactly what they were asking about. She says, I thought it's not, ladies and gentlemen. That's from the defendant's mouth when she's being asked about the dangers that she knew. After telling detective multiple times that she knew it was dangerous, that she knew what could happen, that she knew that what could happen to Amillio, him dying, could happen if she took her actions. I want to know your thoughts, or what thoughts crossed your mind. You said it was irresponsible. Defendant, yeah. Detective McNabb. And I don't think anybody, that's cut off, I apologize. And then defendant, but they were sleeping. I didn't want to wake them up either. I didn't want to wake them up either. What does that one word, ladies and gentlemen? I didn't want to wake them up either. I thought about the options. I thought about the potential consequences. But I also didn't want to wake them up, so I let them continue to sleep, if they were sleeping to begin with. But I didn't want to wake them up either. One word, ladies and gentlemen, can tell you almost everything you need to know. She thought about the consequences, she thought about her choices, and she chose the choice that most benefited herself. It was a lot of time in the hot car, and obviously I don't want to beat around the bush here. Obviously, you know damage can happen from that. Defendant, and in the video, she nods her head up and down. Then you have the phone call with Reiner Gutierrez, the father to Amillio Mateo, that defendant testified about yesterday. You know you did was wrong, don't you? Obviously. Reiner, huh? Defendant, obviously, I'm not an idiot. She's not an idiot, ladies and gentlemen. You heard Dr. Masako tell you yesterday she's not an idiot. Very average IQ, much like most of us in this courtroom. I'm not an idiot. Of course I knew it was wrong because I'm not an idiot. Only an idiot wouldn't know that you can't leave your kids in the car in the heat. That's what this says. I'm not an idiot. Obviously I know it was dangerous. Obviously I knew that. And again, we touched on this earlier. I'm going to go into the defendant's court testimony in just a moment. As I discuss with you the statements made by the defendant, as you consider the defendant's testimony while you're in the back, consider Calcrim 226. That is the instruction that the law tells you the factors you can use in evaluating and judging a witness's testimony. And this is important, ladies and gentlemen. When the defendant decides to take the stand, she is to be given the same weight as every other witness. She does not get extra points because she didn't have to testify. She does not get extra points because she is the defendant. Once she takes that oath, she is a witness the same as anybody else. And ladies and gentlemen, you have heard about the presumption of innocence. The defendant is presumed to be innocent. She is not presumed to be honest. She is not presumed to be trustworthy. So when you consider her testimony, consider these factors. Did the witness understand the questions and answer them directly? You heard multiple times during cross-examination where I asked her a question, she answered initially and then added extra to the end. She understood the question, but she wanted to make sure she got her version of the answer out. Was the witness's testimony influenced by a factor such as bias or prejudice, a personal relationship with someone involved in the case, or a personal interest in how the case is decided? Ladies and gentlemen, the defendant, the witness you saw yesterday, the witness Maya Hernandez, is the only witness you heard from in this case that has a personal interest in how this case is decided. She's the only witness that has bias. She's the only witness that has reason to be untruthful. Next, did the witness make a statement in the past that is consistent or inconsistent with her testimony? This kind of goes hand in hand with the factor above. Was she inconsistent in the past? Yes. What does that tell you? That tells you that maybe she's not being honest with you. That tells you that maybe those biases, maybe her interest in how the case is decided is sneaking through from that stand. Those inconsistencies, different statements when she's testifying than what she said to Detective McNabb, those show you that she's not being honest with you, ladies and gentlemen. How reasonable is her testimony when you consider all of the evidence in this case? The thing with her testimony, ladies and gentlemen, is you can consider how unreasonable it is by only considering it against two other pieces of evidence. You can take her testimony in court and simply compare it to her two recorded interviews and know right off the bat exactly how unreasonable it is. But then when you start adding all the other evidence into the case, it blows her testimony out of the water. When you consider everything, including her own prior statements, you're going to see that her in-court testimony was not reasonable. Did other evidence prove or disprove a fact about which the witness testified? Absolutely, including her own statements. So let's talk.
I'm sorry, we need to take a break. Yep. It's 10:51, so let's take a 15-minute break. We'll have our camera.
All right, Judge, giving that jury just a little bit of a break. Let's bring in our guest with us, criminal defense attorney Joanna Nieves. Joanna, great to see you. And I got to say, number one, I'm terribly impressed by this closing argument by the state. She obviously knows the facts of this case and appears to be extremely passionate about what she's arguing. I want to zero in on what she was just talking about. She really went through this whole thing about inconsistencies by the defendant. And I get it. You have to point those things out. Clearly, she made some statements that seemed to try to cover up some of the things she had done, et cetera, et cetera. But I don't feel like this is where that case is going to be won or lost. I mean, she's a mother. I think this was very traumatic for her as well. I don't think the state is saying that she didn't care about those children or did this intentionally. It's something completely other than that, this conscious disregard for human life. What do you make of what she's arguing now and how this entire closing argument is going for the state?
I agree. I think she is taking her time and laying the facts on bit by bit in order to differentiate between this kind of criminal negligence where you didn't really think about what you were doing versus the actual awareness that you knew there was a risk and you took that risk anyway. And so where she's talking about the inconsistencies, I think it's really to highlight for the jury that now she's kind of backpedaling on that knowledge. She admitted before that things were obvious to her, and yes, she's not an idiot, and she's aware of these campaigns that don't leave your kid in the car, but she did so anyway, and she did it with intention, right? She didn't just forget her kids there or run inside for a quick errand, which, you know, speaks to grossly unreasonable decisions, but at the same time, she gave them snacks, she left them with a phone, she intended to leave them alone in the car for a period of time.
Now, that period of time is, I think, where the issue comes. When you look at this case, you know, people have left their children in cars. Again, that is a crime in and of itself. It's a misdemeanor, again, depending on what results. And obviously, the defense admits that there's that underlying crime. It's a misdemeanor in their estimation. Therefore, she's guilty of involuntary manslaughter. But when you think about this case, it's that time. And one of the things she mentioned, the prosecutor mentioned, is, now we weren't able to show testimony in the case according to the judge's ruling, only the openings, closings, and verdict. But one thing the prosecution did was they played the entire 2-hour tape of her sitting in the lobby. I think it was almost 2.5 hours of her just kind of sitting in the lobby, talking to people, going back, coming back out, sitting. And I think that is where they're really sort of putting all their eggs in terms of that's where this crime really occurred. She never left that place to check on those children. And that's the unreasonable part. That's the conscious disregard for human life.
Oh, I agree. I think the jury's going to look at, hey, you know, quick errands, running into Starbucks, running in to grab something, and you don't want to take everybody out versus 2.5 hours. You know, having an appointment, a doctor's appointment that's essential versus non-essential cosmetic fillers, or even, you know, just the idea of being in a place that allows you to have children inside, seeing children inside, but not bringing your own kids, leaving them not in like 70, 75 degree weather, but triple digit heat. I think, you know, ultimately there's just some really rash and unreasonable decisions that took place, but with the knowledge that those decisions were bad.
Yeah, and you know, anyone who's a parent knows, you know, you get in that position where the kids are sleeping in the back, you know, you're always struggling to put them to sleep. They're sleeping, you don't want to wake them up, so you go inside and then, but again, that 2.5 hours is where I think the issues come. All right, Joanna, stand by. I want to take a break. When we come back, we'll have more of the prosecution's closing argument in the murder trial for Maya Hernandez. Keep it here on your front row seat to justice. Welcome back to Court TV Live. I'm Michael Ayala. I want to get you back to Bakersfield, California for more of the cosmetic filler child killer trial for Maya Hernandez. Now, she's accused of leaving her 2 children alone in a hot car for hours while she went to a med spa appointment. One child did survive, but her 1-year-old son died from the heat. Right now in the courtroom, the state is giving their closing argument. I want to go back in for more.
Welcome back, ladies and gentlemen. Before we left, we were beginning to speak about the defendant's testimony in court. And I just want to remind you that CalCrim 226, which will be in your packet of instructions, is going to be very helpful to you in how you decide to evaluate the defendant's testimony in court. So first, we heard from the defendant that she made an appointment for a liquid BBL in Bakersfield for the date of June 29th, 2025. You heard at the beginning of her testimony on her direct examination, she attempted to kind of characterize this as a last-minute type of appointment that she didn't have prior notice of. But then you heard on cross-examination that she did, in fact, know about this appointment for many days ahead of time, and that she had been working on scheduling this appointment since early May. Plenty of time to make arrangements for her children. Chose not to. She told you during her testimony that she had asked her sister to babysit, and her sister said no. Again, this is another one of those things that might sound fairly insignificant, might be a small point to make, but it shows you that she was not being honest with you. Because you heard in her testimony, or her interview, I apologize, with Detective McNabb, that she specifically talked about her sister and the potential of her sister babysitting. And she specifically says, I know if I asked her, she would say yeah, but I mean, like, I know it irritates her. That is not, I asked my sister and she said no. That is, I knew that was an option, but I didn't want to annoy her, so I chose not to take that option. That's evidence of a lie, ladies and gentlemen. You heard that she took both of the boys with her from Visalia to Bakersfield for the appointment. That she knew before she left Visalia that she could bring the boys inside with her. She didn't bring the boys in with her because they were sleeping. Now, this is consistent with her second statement to law enforcement, but it is inconsistent with her first statement as well as her other testimony in court. And that is the fact, ladies and gentlemen, that she left the TV on for them. If they were sleeping and you don't want to wake them, turning on their favorite show, Paw Patrol, probably is not the appropriate route you want to take. The story that they were sleeping does not fit with the other evidence or the actions that the defendant herself said she took. She also said when she testified that one of her concerns was not the fact that the boys might be running around the lobby while she was in getting her appointment. But you saw, and you can see again if you choose to watch it while you're deliberating, her recorded interview where she does say her concern was that they would be running around. You also now know that there was a solution to that should she have chosen to take it. She told you that she got out of the car about 2 p.m. and went into the business at 4:33 p.m. And it's important, ladies and gentlemen, that you look at these consistencies, and when you look at what she admitted to in court, look at those admissions and compare them to the physical evidence. She admitted and she was consistent with the things that there was evidence completely showing her to have been doing. This was thought out testimony. Again, she's not an idiot. She's a smart girl. She knew what she was doing and she knew what her plan was. She knew what her plan of attack was for her testimony. I'll admit to the things that I can't fight. I'll admit to the things that aren't that relevant. But I'm going to deny the issues. I'm going to deny my knowledge. I'm going to tell them I misunderstood. These were planned actions. This was planned testimony. And I think that came off very clearly throughout her testimony. She admitted that she never left to check on the boys. Again, that's going to be very hard to dispute based upon the video surveillance we watched in court. Acknowledged that she was checking her watch throughout her time in the business and that her watch did in fact display the time when she was looking at it. Left her phone in the car for the boys to watch Paw Patrol, and again didn't bring the boys in because they were sleeping. This is not consistent with watching Paw Patrol, leaving candies and cookies with the boys. And also she admitted to leaving the boys with 1 bottle of milk each, no water. She said that she thought the air conditioner would stay on while she was in the business. And ladies and gentlemen, again, I'm going to point out one word that I want you to pay close attention to. Every time you heard the defendant mention leaving the air conditioner on, she used the word, "I thought it would stay on." Never once did she say, "I knew it would stay on." And that is because she didn't know that, because she had never read the owner's manual. She thought it would stay on, and that thought was wrong. But thinking that the air conditioner would stay on and thinking that that would make her actions okay also tells you that she knew it was wrong and dangerous to leave them in the car in the first place, or else she wouldn't have to reiterate these actions to you. She told you that she did not know if it had stayed on because, again, she never went to check on the boys. She never went to check on the car. She never left the business. She knew she was inside of the business for a long time. And at 3:30, she had confirmation that it would be at least another 20 to 40 minutes before her procedure. So even painting this in the light most favorable to the defendant, at that time, she could have thought, well, I'm not going to miss my appointment, so let me go check on them. But she didn't. Because at no point during that 2.5 hours, during that day, during the Maya day, were her children her priority or her thoughts. She had a stroller with her that she could have strapped the boys in and brought them inside with her. You saw that in defense exhibit number 10. She knew what high temperatures could do to a body. And ladies and gentlemen, not only did she know what high temperatures and high fevers could do to a body, she knew what it could do to her children because she saw it happen to Mateo in the past. More knowledge of the dangers of what her actions could cause that day. She did not tell a single person that her babies were in the car. She told you she didn't tell people because she doesn't tell people her business. Well, ladies and gentlemen, she's chit-chatting for 2.5 hours. If you're really not telling people your business, you're not going to tell them that you're there to get butt injections. If you're really not telling people your business, you're not going to tell them in the first place that you have 2 kids. If you're not telling people your business, you're not going to sit there and talk about your 4th of July plans. If your life is that private that you don't want them to know anything about you, you sit there, you have your hands in your lap, and you are quiet. No need to participate. Or even more so, if your life and your privacy is that important to you, you wait in your car for your appointment. She did not tell people that her kids were with her because she was a private person. She didn't tell people her kids were with her because she knew it was wrong. She knew it was criminal. She knew that could get her in trouble. That is the only reasonable explanation as to why she did not tell the other patrons her kids were with her. It's the only logical.
This prosecutor really tearing this defendant apart, and as you see her sitting there, she's kind of staring off into space. I wonder what she's thinking. We'll take a break here. More closing arguments in the murder trial for Maya Hernandez next. Keep it here on Court TV.
Tonight on Closing Arguments, a deadly shooting at Brown University and a killer at large. Court TV's Matt Johnson is on the ground with the very latest.
Closing Arguments with Vinny Politan, tonight at 8/7 Central, only on Court TV.
'Tis the season for true crime. Each morning we'll dive into a case that took place around the holidays. Join us for the 12 days of holiday crimes.
Opening statements with Julie Grant, mornings at 8/7 Central on Court TV.
Back now to California for more of the cosmetic filler child killer trial for Maya Hernandez. Hernandez is charged with murder and child cruelty after leaving her 2 young children alone in a hot car while she went to a med spa appointment. Her 1-year-old son, Amillio, died. The other did survive. Let's go back inside that courtroom now for more of the state's closing argument.
Logical explanation that she didn't tell the other patron her kids were with her. She didn't tell a single person that she was in a hurry. She didn't look at Shelby, Ian, or the 2 women on the couch. Hey, my kids are with me. Do you guys think I could jump your appointment? Hey, my kids are with me. I'm in a really big hurry. Would you mind if I went first? None of that. She didn't text the nurse and say, hey, I'm in a big hurry. How long is it going to be? Hey, can you get me in? I'm in a big hurry. What she did tell you was that she was blowing up the nurse's phone, essentially telling her she was late for her appointment and was in a hurry. This was a convenient line for the defendant to use until she learned that I had the text messages, that I had the entire conversation between her and Harmony that day, that I knew, and I could point out to you, the jury, that she did not mention one single time being in a hurry. The closest she got to that was asking at 1:59 if her appointment was still on, and then stating that her appointment was supposed to be at 1:30. Instead, at 1:11 p.m., she said, or I apologize, 1:10 p.m., she sends a picture of the building asking if she's in the right place. 1:11 p.m., Harmony responds, yes, hon, go ahead and wait in your car till the time. We're a little backed up, my apologies. 1:12, okay. 1:34, do I go in now? 1:54, again, defendant reaches out, hey girl, 1:59, is my appointment still on? 2:02, yes girl, come in for paperwork. 2:03, is it the room I just took a picture of under the 31? That's defendant. 2:04, Harmony, let me see. 2:47 p.m. I'm in here. I signed the paper, but my appointment was at 1:30. This statement, ladies and gentlemen, does not say I need to go right now. This does not say I'm in a hurry. This does not say how many people are ahead of me. This does not say, hey, Harmony, my kids are in the car. Can you speed this up? Can you get me in? Just simply says, I'm in here. I signed the paper, but my appointment was at 1:30. 3:11 p.m. Harmony says, hey, hon, what are you planning to get done? You just gave a deposit. I apologize for those typos. 3:11 p.m. BBL, the defendant responds. 3:12 p.m. defendant, I did the deal for the payment plan. 3:50, okay. For 3:50 or 3:15, defendant Harmony says, okay, the 3:50 for 600 question mark. 3:16, the defendant says yes. Again, in this time period, between 1:39, 1:40, and 3:16, there's no mention of, hey, I'm in a hurry. Do you have an estimate? Hey, we've been texting. Can I go wait in my car and can you text me when it's time to go? My kids are with me. You don't see any of that, ladies and gentlemen, because that didn't happen. 3:27, Defendant. But they said they would add 50 to the BBL and then another 50 because they rescheduled me 2 times. 3:33 p.m., Harmony. Okay, that's fine. You're next after my client's mom hunt. 3:33 p.m., she knows it's going to be another 20 to 40 minutes, and she continues to sit in the chair. 3:34 p.m., thank you with a question mark. 3:35 p.m. from Harmony, no, OMG, thank you for your patience. Thank you for your patience, Maya Hernandez, as your children are sitting in your car burning to death. None of this conversation, ladies and gentlemen, reflects any intention of I was blowing her up to let her know that I was in a hurry. Again, another lie the defendant tried to tell you. The defendant told you that Harmony was lying when she said the defendant told her that her phone was in the car because it was dead. What incentive, what reason does Harmony have to be untruthful about that? On the flip side, what incentive, what reason does defendant have to tell her that her phone's in the car because it's dead rather than my phone is in the car because my kids are in there? Every incentive, because telling her that her kids have been in the car is her confessing to what she knew was a crime. Her confessing to something she knew was dangerous. Then she starts telling you she did not know it was bad to leave her kids in the car before she did it, only after. Completely inconsistent with her prior statement to Detective McNabb. Did not know it was dangerous to leave her kids in the car before she did it, only after. Didn't realize that detectives were asking her about what she knew beforehand. And then she says, I was just trying to take accountability. I was trying to take accountability for what I did. And ladies and gentlemen, you now know from her testimony and from her actions that when she said, I was just trying to take accountability, what she meant was, I was trying to take accountability until I realized just what taking accountability would mean for me. Again, thinking about Maya. I was just trying to take accountability, and now here I am facing murder. That was a little bit more accountability than she thought she was signing up for. That was a little bit more accountability than she thought she was accepting when she made those initial statements to Detective McNabb. And you have those statements. We've already talked about them. But again, ladies and gentlemen, as I've been telling you, you are going to have to ask yourselves, what did she know and when did she know it? Those answers are going to come from her statements and her actions. Have you heard the radio ads about not leaving your kids in the car? What did you think could happen if you do leave them? Prior to this happening, did you understand? She answers in the affirmative. Yes, I knew prior to this happening. These are very clear questions, ladies and gentlemen. These questions were not random questions that Detective McNabb just came up with. You heard Detective McNabb. He is a seasoned detective. He knew the answers he was looking for, and he knew the questions he had to ask. He knew he needed to get the answers that she knew beforehand, she knew prior, which is why you hear it worded the way it was. Like, prior to this happening, did you understand? What did you think could happen? What happened, I guess? What happened to Amillio? Question mark. Did you know that prior to this happening? Not do you know that now? Not do you understand that or recognize it now? Did you know that prior to this happening? And she talks about having seen the news, having heard people, knowing it in general.
All right, let's bring back in our guest still with us, criminal defense attorney Joanna Nieves. And Joanna, you know, the state is proceeding on two theories, which I think bodes well for them in terms of getting a second-degree murder conviction. The first one is this implied intent, not that she intended to kill her kids, but implied intent because of conscious disregard for human life. And then there's a second one she talked about with the jury, this failure to protect. She breached her duty as a parent, resulting in the death of a child. Both of those seem, at least according to their arguments right now, we still have to wait to hear from the defense, but seem to fit well. The facts of this case seem to fit well into both of those.
I think I could see it go both ways. I think the jury's really going to rely on the first one, the implied malice, and the awareness of the risk and the choices she made in line with that. There are some jurors who know what it's like to be a mom and know that sometimes you just don't want to be around your kids, and that is okay, but it's not okay to leave them in sweltering heat knowing that it could lead to potential death. So the failure to act as a mother should act can be subjective depending on where people are. But I think everybody can agree that leaving your kids in triple-digit weather is definitely not protecting them the way that you should.
Yeah, and I see the one path for the defense here is exactly what you're talking about. This idea you are asking the jurors, all of them, again, they have to be unanimous, that this is a mother that left her children to die. We're going to convict her of murder. And again, if you've been a parent, some of these things are familiar to you. Some of these decisions you've made in the past, and you, by the grace of God, are not in that position. Perhaps you dealt with it much better than this particular defendant. But I think you're also looking at asking these jurors to do something difficult, would you not say?
Yes, definitely. I think it's just a hard case. It's a tragic case. This one-year-old child is gone and there's no bringing him back. And so I think that the jury is going to find that the most compelling fact here, despite the fact that she's a mother, we can't bring the kid back, and they're going to be focused on that.
Yeah, there's no question about it. That is the worst part of this case.